legal and illegal strike or lockout. When are strikes legal and when they are illegal? When are lockouts legal and when they are illegal? General prohibitions. Okay, there are two types of industries. One comes under PUS, public utility services, and other comes under non PUS, not public utility services. Okay, public utility services are the essential services, important services which are very important or essential for the public. Okay, we have already covered it in the previous video. You can check the details there. Okay, so the industries which are not under PUS, which are not public utility services, it is said about them that under section 23, strike by workmen or lockout by employer can be declared without giving notice. Okay, so in industries or services which are not PUS, no need of notice. Okay, and in the industries or services which are PUS, notice has to be given. Okay, and what is more about not non-PUS? Okay, what is more about non-PUS? That no strike or no lockout can be done in breach of contract. Okay, so no lockout or no strike can be done in the breach of contract between employer and workmen during the pendency of. Okay, when it cannot be done, it cannot be done during the pendency of conciliation proceeding before a board or 7 days after the conclusion of the proceeding. Okay, it cannot be done during the pendency of conciliation proceeding, and it cannot be done during the pendency of proceeding before labor court, tribunal or national tribunal. Okay, or 2 months after the conclusion of the proceeding. Okay, during its pendency also. It cannot be done during pendency of arbitration proceeding before a arbitrator or 2 months after conclusion. Okay, during these three types of proceedings, during their pendency, okay, there cannot be strike or lockout in the breach of the contract, or during any period or of operation of settlement or award in matters covered by it. Okay, if there is a settlement or award, so there can be no strike or lockout in that period in relation to any matter which is covered by this settlement or award or decision by these courts or tribunals. Now see what are the conditions for strikes and lockouts under public utility services. Under section 22(1), it is said that no strike can be done in breach of contract between workman and employer without giving notice to the employer. So in public utility services, a notice should be given before strike or lockout within 6 weeks before striking. Okay, the workman should give the notice of a strike before 6 weeks. Okay, 6 weeks before the strike, and it cannot be done no strike within 14 days of notice or before the date of strike specified in notice. If there is a date specified in the notice about the date of strike, then there can be no strike before that date, or there can be no strike during pendency of a conciliation proceeding before conciliation officer or 7 days after its conclusion. Okay, so no strike can be done during the pendency of the conciliation proceedings or the conclusion of conciliation proceeding 7 days after its conclusion. Section 22(2) says there can be no lockout in the similar circumstances. In all these circumstances, there can be no lockout. When is notice not necessary? No notice is necessary for strike if lockout is in existence, or lockout if strike is in existence. Okay, if there is already a lockout, then there is no need to send notice for the strike. If there is already a strike, then there is no need to send notice for a lockout. Okay, no need of notice. Employer send intimation about strike or lockout to authority as specified by appropriate government on the very date it is declared. It has to inform the government or the authority specified the government about the strike or lockout. Okay, on the very day it is declared. Workmen send notice on the very date it is declared by such number of persons to such persons in such manner appropriate government prescribes. Okay, the workman has to send notice about their strike on the very day it is declared. Okay, the number of persons by which it is to be sent or to whom it is to send, and in what manner the appropriate government prescribes the manner, the numbers, or the person to whom it has to be made. Employer reports to appropriate government or authorized person within 5 days of receiving notice. If an employer gets a notice from the workman about a strike, then he has to report about the notice to the appropriate government or the authority prescribed by the government within 5 days of receiving this notice. In what circumstances an strike or lockout is illegal? It is illegal if it is against provisions of Industrial Disputes Act. Okay, if the strike or lockout is against the provisions or laws or rules of the Industrial Dispute Act, it is illegal. In section 24 it is said, if it is commenced or declared in contravention of section 22, 23. Okay, if it is started or declared in contravention of these acts are the public utility services and non-public utility services, which we have read before above. Okay, if it is in contravention of these sections, then it is illegal. Or if it continues in contravention of order made under section 10.3 or 10.4a4. What are orders made under section 10.3, 10.4a4? It is when there is an industrial dispute, okay, and there is a strike or lockout going on due to it, and if the appropriate government thinks that the industrial dispute should be referred to any board or labor court or tribunal or national tribunal, then it refers the industrial dispute. Okay, so okay, it refers this industrial dispute to this labor court, tribunal or tribunal, and when it refers the industrial dispute, it gives an order that the strike or lockout, their continuance is prohibited. Now you cannot continue the strike or lockout related to this industrial dispute. So if anyone continues it in contravention of the order, okay, the order was given to prohibit the continuance, to stop the strike or lockout. Okay, if someone then also continues it, then it is illegal strike or lockout. In what circumstances the strike or lockout is not legal? It is legal if it is not in contravention of provisions of act. Okay, if it is not in contravention or against, or it does not violate the provisions or rules or laws of the Industrial Dispute Act, it will be legal. It will not be illegal. If it is in continuance, if its continuance is not prohibited under section 10.3, 10.4a4, if the strike or lockout, it is this the strike or lockout related to the industrial dispute, it was prohibited. If there is some strike or lockout which is not prohibited by the appropriate government, by the order of appropriate government, if it is in continuance, not prohibited under section 10.3, 10.4, it is legal. Okay, or strike or lockout declared in consequence of illegal strike or lockout respectively. Suppose there is a illegal strike going on, then in consequence of this illegal strike a lockout is declared. This lockout is legal. If there is an illegal lockout and in consequence of this illegal lockout there is a strike declared, it is an legal strike. Okay, what are the consequences and penalties for illegal strike and lockout? For illegal strike, any workman commences, continues, or acts in furtherance. If any workman starts illegal strike or continues the illegal strike or acts in furtherance or progress or forwarding the illegal strike, then there can be imprisonment up to 1 month or fine up to 50 rupees or both. Okay, the wages he will not be entitled for the strike period. Okay, he will not be entitled to the wages for the strike period, or there can be disciplinary action taken against him. If there is illegal lockout declared or started, commenced, or continued or act in furtherance of illegal lockout by any employer, then there can be imprisonment up to 1 month, fine up to 1000 rupees or both. If any other person, okay, does illegal strike or lockout, like section 27 say, if any person instigates, incites, or acts in furtherance of illegal like strike or lockout, then there can be imprisonment up to 6 months, fine up to 1000 rupees or both. Okay, section 28 says if anyone finances, okay, gives financial support or money for any illegal strike or lockout, then there can be imprisonment up to 6 months, fine up to 1000 rupees or both. This was illegal and legal strike and lockout. Let's have a quick revision. Illegal and legal strike and lockout. General prohibitions. In not public utility services, there is no need to send notice, okay, for legal and illegal and strike and lockout. Strike by workman, lockout by employer can be declared without giving notice. No strike or lockout, okay, can be done in breach of contract during the pendency of conciliation proceeding before labor court tribunal, national tribunal, or arbitration proceeding before arbitrator, or during any period in which there is operation of settlement or award or decision. In case of public utility services under section 22(1), no strike can be done in breach of contract without giving notice. Okay, in public utility services, a notice should be given to the employer within 6 weeks before striking, or within 14 days of notice, or there can be no strike before the day of strike specified in the notice, or during the pendency of conciliation proceeding before conciliation officer. Section 22(2) says there can be no lockout in the similar circumstances. No notice is necessary for strike if lockout is in existence. If there is a lockout, then there is no need to send notice for strike. If there is a strike in existence, there is no need to give notice for lockout. Okay. Employers send intimation or information about strike or lockout to the authority specified by appropriate government on the very date it is declared. Workmen send notice on the very date it is declared. Okay, workmen send the notice about the strike when it is declared by such number of persons to such persons in such manner as the appropriate government prescribes. Employer report to the appropriate government or authorized person within 5 days of receiving notice about that lockout or strike. Circumstances in which strike or lockout is illegal. It is illegal if it is against provisions of Industrial Disputes Act. It is illegal in, like section 24 says, if it is commenced or declared in contravention of section 22-23, which were about the terms and conditions for strike or lockout in PUS and non-PUS. Okay, if it continues in contravention of order made under section 10(3) or 10(4)(a)(4). We have seen what are orders made under 10(3) or 10(4)(a)(4). When any appropriate government thinks that the industrial dispute should be referred to the board, tribunal, labor court, or national tribunal, then it refers to them and passes an order which prohibits the strike or lockout related to that industrial dispute. So if it passes the order to prohibit the continuance of the strike or lockout and someone continues it, then it is in contravention of order made under section 10(3), 10(4)(a)(4), 10(a)(4)(a). So it is illegal. In which circumstances the strike or lockout is not illegal? If it is not in contravention of provisions of Industrial Dispute Act, or its continuance is not prohibited under section 10(3)(a)(4)(a)(4). If the order made by the appropriate government for prohibiting the continuance, the strike or lockout doesn't come under that order. Okay, its continuance is not prohibited, then it's legal. If strike is or lockout are declared in consequence of illegal strike and lockout. Okay, if there is a illegal strike going on, then the declaration of lockout is not illegal. If there is a illegal lockout going on, then the declaration of a strike is not illegal, it will be legal. What are the consequences or penalties for illegal strike or lockout? Illegal strike. If any workman commences, continues, or acts in furtherance of illegal strike, then there can be imprisonment up to 1 month, fine up to ₹50, or both. The wages, he will not be entitled for wages for the strike period. There can be disciplinary action taken against him. Illegal lockout. If any employer commences, starts, or continues, or acts in furtherance of illegal lockout, then there can be imprisonment up to 1 month, fine up to ₹1,000, or both. Or any other person, like in section 27 says, if any person instigates, incites, or acts in furtherance of illegal strike or lockout, then can be imprisonment up to 6 months, fine up to ₹1,000, or both. Section 28 says if anyone financially supports or finances any illegal strike or lockout, then there can be imprisonment up to 6 months or fine up to ₹1,000, or both. So this was illegal and legal strike or lockout. If you want the PDF for revision of this labor and industrial law notes, you can get the PDF link in description box or comment box. Next topic will be closure.